Please be seated. This is the time scheduled for oral argument in our case number 1 CACV 13-0051, Rodney Sands versus Bill Case, Tempe Dodge, Inc. et al. Each side has been allocated 20 minutes for oral argument. If the appellant desires to reserve any time for rebuttal, you can do so. There's a clock in the podium. The clock shows how much time you have left, including your rebuttal time. So you have to manage your own time. To assist you both, you should be aware that we have read the briefs in this case, looked at pertinent portions of the record and cases and statutes, and have conferenced the case. So we're relatively familiar with the issues and law and the facts. Finally, you should be aware that we are audio and video recording these proceedings. So when you approach the podium, please clearly state your name and whom you're representing. With that, counsel for the appellant.
Good morning, Judge Kessler, Judge Norris, Judge Portley. My name is Thomas Baker, and I represent the appellant Rodney Sands. And as you know from the pleadings, this involves the purchase or attempted purchase of an automobile. What may have not been emphasized, and I'll take the time to do it briefly, is in the September of 2010, there was a new model year coming out for the Grand Cherokee, and this was a limited edition, very hard to find, and very limited distribution amongst retail sales outlets by the manufacturer. And my client was able to get in early and negotiate the contract he did. And I know you've been provided various copies of it, and they may be difficult to read. I hope you have one that's not just a blur. It's both hard to copy and hard to scan. But I don't think we dispute the actual terms of the contract here. But when he got in, he negotiated it. He was required to put $4,000 down, which he did. Wrote the check out. And the contract itself, the purchase contract, stated that it was a deposit of $4,000 and then subject to customer approval when car arrived. So client had or appellant had the ability to essentially void the contract should he not give approval. I'm sure there would have been read into that a good faith requirement on the approval. However, when the car did come in, and it came in October with a slightly damaged trunk lock, which was subsequently repaired for $153 by the dealer. Numerous statements were made leading my client to believe that he could not accept delivery because the dealer was not authorized by the manufacturer to sell it to anyone because it was so substantially damaged. We know the true facts now were that they had sold it to a couple in Tucson because they were able to sell it for additional monies. During this time period, numerous statements were made to the client.
What does the record reflect in terms of the difference between the contract price your client had and the sales price to the Tucson couple?
We didn't actually get the contract that they used to sell. We got the MVD records showing it had been sold.
Okay.
It had been sold as of October 16th, and police don't deny that. We know that they argued in their proceedings that there was a clause allowing them to jack up the price, even though it's a purchase contract for a fixed sum. They claimed, well, we could have raised that price anyway because there's boilerplate language on the back that says if we receive or if we have to pay additional amounts from the manufacturer, then we will add those to your purchase price. So don't rely, essentially, what that clause says, don't rely on the price you negotiated because we might jack that up on you anyway.
Okay, counsel, why don't we get to the, could you proceed to the why the consumer fraud claim should not have been dismissed?
Yes, thank you, Your Honor. As you know, there are three primary issues: the consumer fraud, the incidental damages, and the attorney's fees. Under the consumer fraud standard, the statute states that the act, use, or employment by any person of any deception, deceptive act, or practice, fraud, pretense, false promise, misrepresentation, concealment, suppression, or omission. Very broad category of things the seller is prohibited from doing.
And why did the trial court dismiss the consumer fraud claim?
The trial court didn't state specifically, but I believe they accepted Appley's arguments that even if we did make all those deceptive acts, those false promises, those misrepresentations or concealments, they were done after you signed the contract. So therefore, they couldn't have been in connection with the sale, as it says in the statute.
And your argument is that those deceptive acts, allegedly deceptive acts, deterred your client from seeking to buy a vehicle from somewhere else?
Correct. They were leading them along, even though the contract had been signed, the $4,000 tendered, there was a provision upon acceptance. And and the vehicle at issue, because it was a limited edition, was identified specifically by VIN number. It was the only one they got that year. And that's why they couldn't get a replacement. They weren't available. And if they were at premium prices. They eventually found one in Las Vegas, but didn't want to pay the difference, dealer-to-dealer price. So the acts, even though the contract had been signed, the money tendered, it was subject to delivery. They made those numerous false representations during this period, dragging them along, telling them, finally, we can't sell to anyone, we're prohibited doing so, when in fact, they'd already paid $153, had that chunk left.
And the damage to him was
the tying up of the money and his inability to get in and get another. It took him a year to get another one because it was a limited edition. Dealers didn't have them. The dealers were only allocated one vehicle per dealership if you could get it.
What about the hitch? I mean,
And he went in there specifically and told them, I have this big RV, and you know how RVs tow vehicles. And the tow bars for the vehicles are make model specific. So when he went in there, I said, I'm getting the 2011 limited edition Jeep Cherokee. I need these tow bars made. The vehicle isn't going to arrive for about 2 weeks. So he went ahead, had those made, spent the monies, had them made, and of course, didn't get his vehicle.
so the core of your argument is that the statements allegedly made to Mr. Sands by the salesman about essentially having difficulties in transportation, it's on the train and so forth, are sufficiently connected, so they're in connection with the sale.
Yes. And of course,
And-
excuse
sorry,
me,
go
go ahead. The core statement is, right in the contract, we will sell you this 2011 VIN number with 12 miles on it.
Okay, and that the detrimental reliance is because he waited and was, as under your point of view, led on.
Yes, he was.
He waited. It took him a number of months to get the replacement. He invested some money in the hitch. He did tie up his money, although the check wasn't cashed. I guess he had to reserve it so that he didn't bounce the check, is
Correct.
the point. And that's sufficient detrimental reliance in connection with this agreement for sale to have, so that is the reason why the court should not have dismissed the consumer fraud claim.
Yes.
Okay.
And if the appellee disputes those facts, we didn't say that. We didn't really do this. We didn't really sell them to Tucson, or whatever dispute they might raise, which they didn't in the trial court, be a tribal issue of fact.
Now, what about, unless you had anything else to add about the consumer fraud?
No, Your Honor, that's fine.
Okay,
We'll
then we
move on.
turn to the consequential damage issue.
Yeah, that was an interesting one because I couldn't get the trial court to elaborate on his reasoning. And when it just came out almost sua sponte in the first minute entry, stating that there is no claim under the contract theory for incidental or consequential damages for loss, use, enjoyment, or rental value. We filed a motion to reconsider and then eventually a post-trial motion for new trial, trying to find the court's reasoning of whether that was a factual determination or a legal determination. And we couldn't get him to clarify. But it appears to be, because it wasn't even briefed or raised by the parties at the time that minute entry came out, that it was a legal grounds. The court found that apparently there's no claim under, he says, the contract theory for incidental or consequential damages. We responded by citing the state's UCC provision, ARS 47-27-13, which states that the measure of damages for non-delivery or repudiation by the seller is the difference between the market value at the time when the buyer learned of the breach and the contract price, together with any incidental and consequential damages provided in this chapter, parens 47-2715. If you turn to ARS 47-2715, which is the buyer's incidental and consequential damages statute, Section B states consequential damages resulting from the seller's breach include: 1, any loss resulting from general or particular requirements and needs of which the seller at the time of contracting had reason to know. Client states in his affidavit that at the time he originally negotiated the contract and tendered his $4,000, reserved his right to inspect, that he told, and we say the salesman, this is a fleet director. He is not your salesman that runs out in the parking lot. This is managerial staff. That he had his motorhome. He was purchasing this vehicle specifically to tow behind it, that he was having those tow bars made, and that's what he was going to use it for, traveling. And the court, when it issued its minute entry, simply stated that incidental or consequential damages don't exist. Now, certainly if it was a factual issue, we raised enough facts in his affidavit to make a tribal issue. If it was a legal issue, we believe it was incorrect, a legal ruling, that ARS 47-27-13 and 15 provide for incidental or consequential damages from non-delivery or repudiation by the seller.
What about the effect, or what is your view of the effect, if any, of the disclaimer of consequential damages in the purchase agreement?
And one of the cases cited says, hey, if a seller wants to limit his consequential damages exposure, put it in the contract.
Well, it's in the contract, isn't it?
Well, there's 7 provisions in the contract, none of which, all requiring signatures, one of them having to do with consequential, that's unsigned and unassented to by my client. So they're in the form contract. And I know it's difficult with the copies. We had to shrink them because it's one of those old long forms. But they're in red, and they have initials. And every one of the initials is blank, all 7 of them. Simply did.
Well, you would think that if there's a line for signature, it doesn't apply unless the purchaser signs.
Yes, they're sent to the attorney. Why else would you put in your initial sign here? You're giving up or limiting your consequential damages. That's an important right. Sign here. It's not. So Judge Norris, that's how I would address that issue, that maybe, perhaps they attempted to, or maybe under some circumstances they do limit them, but not so in this case. Having said that, I'd like to reserve. Unless there's any questions at this point.
Questions?
No.
Okay, thank you.
Thank you, Judge.
Good morning, Your Honors. May it please the Court, I'm Doug Tobler. I represent the appellees Tempe Dodge and Dave Zinkel. I think that that you focused in on some of the important points that the appellant has failed to consider. The first and most important point is that Tempe Dodge has always admitted that it made a mistake. It has done that from the beginning and has tried to correct the mistake from the beginning. This is a plain and simple breach of contract. Let's talk about the issues that you've raised. The first one was the consumer fraud claim. Although Mr. Baker, with some help from the court, has tried to change what his allegations were and what is actually in the record. In the record, the complaint paragraph 31, and in his statement of facts in connection with the motion for summary judgment, item 26, paragraph 18, he makes clear that the statements that he claims were untrue were made for the sole purpose of getting him to purchase a substitute vehicle. He calls it bait and switch several times in his pleadings, but he also admits in that same paragraph that he didn't do it, that there were statements made and that he didn't rely on them. And we have cited the court to Kuhn versus Stanley, which says that every consumer fraud, just assuming this was, does not create a private right of action. The private right of action exists only when there is detrimental reliance. And here there was no detrimental reliance. By the way, you raised the issue of him buying a tow bar for his car. The record also reflects that he didn't lose anything on that. He eventually bought a substitute vehicle.
Well, that's true at the end of the line.
Yes.
That he was able to use the hitch he had purchased for the replacement vehicle. But he says in his affidavit, and I told Mr. Zinkel, I was purchasing this vehicle to tow behind my RV, and I was going to have a towing hitch custom made. So he went out and made arrangements to have a hitch custom made. So isn't that detrimental reliance?
Well, there are two issues there. The first is it's not detrimental reliance with damage, which has to exist because he used the hitch. The second issue is that that's not raised in any of his pleadings as a damage. He doesn't claim that he's out $450. You can look at any pleading in the case. He doesn't include that as an element of damage. So it isn't.
That's another matter. I mean, it may well be that his damages have not been well developed, but for purposes of whether he met the elements of a consumer fraud claim on liability to withstand summary judgment, you've got the hitch, you've got the statements that he really didn't go out and look for another a Jeep. He relied on that. Why isn't that detrimental reliance when you look at it as a package?
Well, it is not detrimental reliance because he doesn't say that he did those things based upon the statements that were made to him after the sale contract was consummated, after it was executed. He did those things based upon the original contract. There are no claims that there was any consumer fraud.
Let me ask you,
Yes.
and this is, I think, the point we get to the statutory language, the point you're making. The statutory language says, or basically said, it defines an unlawful act as the act, use, or employment by any person of any deception, deceptive act or practice, et cetera, in connection with the sale or advertisement of any merchandise. What does the phrase "in connection with" the sale mean?
All right. I think that that's self-evident. It's in connection with anything involving the sale. However, the second part of that is whether or not there was consumer fraud here, which we don't believe there was, but whether or not there was, there still has to be an element of reliance on that. In Kuhn versus Stanley, there was presumably some consumer fraud. There were things that were not were not right. There were misrepresentations, et cetera. But because the buyer in that case didn't rely upon those, it didn't create a private right of action. The same thing exists here. And let me take another step on that. One of the elements of a private action for consumer fraud is damage. The damages here are exactly the same on the contract case as they were in the consumer fraud case, because as we go into in our brief, the only consequential damages that were alleged were the so-called lost rental value. And as we pointed out in our brief, the lost rental value, the problem is that the only evidence of lost rental value in this case was clear hearsay with absolutely no foundation. And so whether or not the damages for consumer fraud here are identical to the damages for breach of contract. And those damages were $2,500 and some odd dollars, and the court awarded those damages. So it's an issue that really has no impact on the case.
I'm sorry, are you saying that the amount of damages awarded was based on the rental value?
No.
That was
I'm
the
saying
difference in
the
price.
amount, the actual damages that were awarded were the difference that he claimed between the what he had contracted with Tempe Dodge and what he had paid for
Right.
a
So
new
now,
vehicle.
what's your point about the lost
Okay.
rental?
Okay, what I'm saying is those are the only damages, no matter whether it's no matter what you call it, whether you call it consumer fraud, whether you call it breach of contract, the damages are the same. The damages are the $2,500 and some odd dollars that he was awarded. So it's really a red herring to claim that the consumer fraud issue is of any import.
Well, it is, I think, of import, because if he's entitled to pursue that claim, he has a claim for punitive damages. Now, it may not be a very good claim, but arguably, he is entitled to punitive, at least to assert a claim for punitive damages.
Well,
isn't he?
I don't believe he is, because we filed a motion for summary judgment on the punitive damage issue, and he didn't produce any evidence of an evil
No.
mind, and that's already been decided by the trial court. He had an opportunity to present that, and he did not.
Well, but this appeal doesn't have really anything to do with punitive damages. If we end up, let's say we end up disagreeing on the consumer fraud claim, then you all can duke it out again on punitive damages. I mean, at this point, if he has a legitimate, excuse me, that's not the right word, forgive me, if he has a cognizable consumer fraud claim, then he will be in a position where he has to prove liability, and then he has to prove up his damages.
Well, the answer to that, I don't believe that's true, because he has not appealed the summary judgment to the extent that punitive damages was a separate issue before the trial court, and the trial court denied that.
Court, as I understood it, the argument, and correct me if I'm wrong, the argument below was that if there are no actual damages or there's no consumer fraud claim and no actual damages from consumer fraud, you can't get punitive damages.
Well, I think that's part of it, but there was also no evidence adduced by the plaintiff to create an issue of punitive damages, and that was the time for him to do it at the time that the motion for summary judgment was.
When your motion for summary judgment on punitive damages, what was your argument?
I wish I could tell you that without looking at it, Your Honor. I would be, because that was not an issue that was raised in his brief, I did not look at that.
I understand that, but technically, the opponent to a motion for summary judgment doesn't have to submit anything if the motion for summary judgment doesn't make the case that you're entitled to judgment as a matter of law. So if you come in and say, for example, I'm not saying this happened, but I'm just trying to explain. If you come in and say to trial court, no actual damages under consumer fraud, no reliance on the consumer fraud, or reliance that caused damages. Therefore, I get summary judgment on the consumer fraud claim, and that also gets rid of the punitive damage claim. He comes in and argues about the consumer fraud and the damages under consumer fraud. He doesn't then have to say, oh, and here's my basis for punitive damages, because you haven't argued that.
Yeah, I understand your argument, and I would have to look at
Well, we would.
whether or not, we also said that there was no evidence of an evil mind. If we did, then that issue is precluded.
Let me, I have the index of the record on appeal here. I
Yes.
just want to, on this punitive damage issue, did the dealership raise the issue of punitive damages? We can go back and look to see exactly how it was argued, of course, but was this raised in the initial round on the summary judgment motion that preceded the arbitration?
Yes.
So it came up then?
Yes.
Okay.
Yes, it did. I think we've made our point, whether or not the court agrees with it, and I don't want to beat a dead horse. The fact is that we tried this case and we litigated this case based upon the representations and the factual statements made by the plaintiff, the appellant. And the appellant was the one who told us that the basis of his consumer fraud claim was that there were representations made to him after the fact of the contract. That was his only claim to any consumer fraud. And he specifically stated more than once that he didn't rely on any of those claimed misrepresentations.
Now I've lost you.
Okay.
Okay.
Yes.
I thought you were saying that his original claim was all the misrepresentations were made as part of the inducement to get him to buy the vehicle.
No, and I'm glad you asked that question.
Me too.
He signed the contract in September. In October, he claims that there were misrepresentations made to him. He does not claim that he did anything in reliance on those. He says that they tried to sell him another car and he didn't take it. So in fact, he was committed to buying the car. It's a clear breach of contract case, and that's it, because he didn't do anything in reliance upon any misrepresentations. He didn't
take
get
the
the
bait.
What's that?
I guess put perhaps somewhat crassly, he did not take the alleged bait. He didn't take the other vehicle.
Yeah, obviously we don't claim
I
that,
know,
that there was
I
that.
understand that.
And as you know from reading the part of the briefs on attorney's fees, Tempe Dodge did everything in its power to take care of this mistake, including offering him the exact same vehicle, and he didn't want to do it. He didn't want to buy the same vehicle, including offering him money, including offering him. They basically made a mistake, no doubt about it, and tried to make it right. But the claimed misrepresentations had nothing to do with any damages that he claims. His tow bar was already purchased, so he didn't rely on that in purchasing it. He didn't rely on anything they said in waiting, because he said, I wasn't going to do any business with them at all after they came back to me. So there was no reliance, nothing whatsoever. And I won't go into the consequential damages, because I think we made that point clear, that it's based on hearsay and no foundation.
That was apparently not what the court ruled on. Court didn't say this was inadmissible as a matter of admissible hearsay.
Okay. They did not specifically say that, but as I was listening to the last hearing, and the point was made that that this court will assume that a trial court ruling was based upon all the evidence in front of it, and we did object, and there is no evidence. There's simply the court would have committed error, the trial court, if they had considered that evidence. So we can, and also, as this court knows, you can affirm based upon different criteria than the trial court. And Mr. Sands and his attorney have yet to even argue that the evidence of consequential damages was admissible, that it was not hearsay. So whether or not that was the basis for the trial court, this court can affirm on that basis.
Would it have been hearsay for purposes of summary judgment if the affidavit had said, I've learned that the rental fees, just stated,
Right.
not learned,
I've
the rental
determined.
fees, I've determined that the rental fees would have been between $74 and $95 a day. Would that have been hearsay?
That would not have been hearsay. However, he would have still had the problem with foundation. While an owner can testify as to the value of property, an owner cannot necessarily testify unless he can show that he has knowledge as to the rental value.
Based on my review of rental values in the valley, I've determined that the rental fees were $74 to $95 a day. Would that have been admissible?
I don't think so, not unless he gave you some foundation for that. What is his review?
Okay.
All right. But in this case, who are we to cross-examine? I mean, who would we go to find out whether or not that was actually the rental?
Perhaps Mr. Sands
Well,
could have gone to him and said,
okay, but he didn't say that. It's a hypothetical the court raises, but that's not what the evidence was.
Right.
It simply wasn't. I mean, there are other problems with the consequential damages claim, which we've pointed out in our brief. Among those is that the incredible windfall Mr. Sands would get from consequential damages.
That's a hypothetical of if it would gone on for years and years.
Well, but even though it didn't go on for years and years,
And then-
he's claiming.
But then there's the issue of mitigating your damages. In other
Yeah,
words,
well-
if I want to rent something for $74 a day rather than buy something for about the same price, the argument would be, well, you've got to mitigate your damages.
Exactly, and here he didn't pay any money. As Judge Norris pointed out, he gave him a $4,000 check to hold, never cashed, it was never supposed to be cashed. He didn't pay anything.
What about not looking around for another vehicle because during the time period when he was allegedly being misled?
Well, there's no evidence of that. The evidence was that he went to the dealership, he found out that they weren't going to sell him, and then he started looking for a new vehicle, not because of him being any misrepresentation, but because they didn't deliver the vehicle to him. We have to rely on what's actually in the record, not what he might argue. And there is nothing in the record on that. If there are any other questions, I'd be glad to respond to them. The other issues I think we've covered adequately in the brief, and I thank you for your time.
Thank you.
Thank you, and there's just 3 points I'd briefly touch upon. I think the biggest grand misrepresentation made to my client was the initial statement is, we'll sell you this brand-new limited edition 2011 Jeep Cherokee, VIN number specifically identified with 12 miles on it, specifically identified for the purchase contract. The appellees have always taken the position, and they like to sidestep the statements. They never specifically address them, but they say that this was a mistake, an oops, an error. The error or the mistake they're referring to is their fleet manager, not a car lot salesman, had sold the vehicle to the couple in Tucson. And at the same time, he's telling my client, well, we can't fix it, we can't sell it to you, we'll try to get you another one, still leading them on, knowing full well that car isn't there, we already sold it. So that isn't an oops, we're sorry mistake, that's a conscious pattern of conduct. And I was queried with appellee, the punitive damages component, I believe, fell by the roadside when the court granted summary judgment on the consumer fraud claim. Without the consumer fraud claim, he didn't even get to the damages part. He simply said, read his minute entry. Motion is granted on consumer fraud claim and claim for punitive damages. They're together. You can't have punitive damages without the consumer fraud. So I think with the conscious course of misrepresentations and deceit that we would have been able to show. And even again, if it's a weak claim, it's still a claim we're allowed to present to the trier of fact and allow them to render their decision.
In this case, the trier of fact ultimately would be an arbiter.
No, because it was precluded before we got there.
Well, but to the extent we were to send it back, it would still go to arbitration.
I would assume so, because it would be a redo. And that's fine. And when we got to the arbitration, we were just limited to, the difference between what you paid and the difference between what everything else was off the table. And the last point, just briefly, the consequential damages evidence. It was never raised in the summary judgment pleadings, inadmissible hearsay.
Well, they did object to your statement of facts where you raise, in paragraph 49, I believe, in your statement of facts, you say the rental value was 74 to 95 or 90, whatever it was.
Sure.
And in their objection to it, they did say that's hearsay and lacks foundation.
Their primary argument, and I believe this is, again, we weren't able to determine, but the thrust of their arguments on their reply were, well, look at our contract. It has a place where we can exclude those. We'll rely on that. And that's the first time it came up with their reply proceeding, as I recall, their reply brief to the motion for summary judgment is, well, it's a term of the contract. Of course, it wasn't assented to, but it's in there. Therefore, no consequential damages. And I think it's unfortunate that we're in a position trying to guess the trial court's reasoning. If you could just say that matter of law, fine, we could deal with that. Matter of fact, we could deal with that. Now we're kind of juggling what was in his mind when he issued that. That's all I have. Thank you all.
Well, thank counsel, both counsel for their arguments. We'll take the matter under advisement and issue a decision in due course. With that, the court stands adjourned.